Well, good evening, everybody, and welcome back to AJ 101 Criminal Law Online. And tonight's lecture is going to be on homicide. Now, it's a fairly long lecture, but I'll try to keep it as brief as possible, as I've really tried in a couple of the other chapters that are a little bit longer. So, again, this would be a great chapter for you to fill in the blanks by reading the book and taking the terminology quiz to help you kind of understand some of the definitions as well, and even taking some of the time to look at the discussion points that they might have listed within your textbook as well, because I think all of these will help you out. So I'm also going to post a video on a particular case that you can review as well, and it'll kind of give you an idea and add a little bit more context to the chapter as we move through this chapter and what have you. So chapter 11, homicide. So let's start off kind of with defining what homicide is. So the term homicide describes the killing of a human being or viable fetus by another human being. The killing may be either justifiable or excusable, in which case it is not unlawful, or it may be felonious, in which event it would be a crime. Now, the word homicide is used to describe all taking of human life by human act or agency, whether lawfully or unlawfully, and you can find that in Penal Codes 187 through 199. And the killing, the unlawful homicide, must be either the result of an affirmative act, an omission to act, meaning the failure to act, or criminal negligence. And we'll talk a little bit more about that in a few minutes. Although the act not be the only cause of death, it must be what they call proximate cause or direct cause, and the death must occur within 3 years and 1 day after the cause of death is administered, or it will be presumed that the death did not result from that actual act, if that makes any sense. And that's under Penal Code 194. So kind of an interesting set of circumstances that they have here. Now, we typically always use the word murder, and that's okay. That word, people get its meaning and they understand it. But just understand that the term homicide describes the killing of a human being, justifiable or excusable, or in any other circumstance. But the term homicide is one that's very interchangeable as we talk about this subject. Now, I'm going to try not to confuse everybody too much on this, but we're going to hit this word, this phrase again, called corpus delicti, and we talked about it in a couple chapters back, and it can seem a little bit confusing, but we're going to try to make it so it's not. So this term, corpus delicti, meaning body of the crime, is the essential elements of an offense and does not necessarily refer to the body of a deceased person in a homicide case. This is especially true in California, since actually producing a dead body in a criminal homicide case is not an essential element of the crime of murder or manslaughter. Now, there's a case, People versus Scott, that can add some more kind of information to that. So also, criminal homicide cases may be proven by direct and or by circumstantial evidence. So the corpus delicti, to kind of give you a little bit more of an understanding of felonious or criminal homicide, consists of two basic elements. And the first one would be death of a human being, and the second would be an unlawful act, omission, or criminal agency causing such death. Now, it's not necessary that there be direct evidence as to the means used to accomplish the killing and attempting to prove the corpus delicti of homicide. Such may be proven, as I mentioned just a couple minutes ago, by circumstantial evidence. So criminal homicide cases, again, can be proven by direct evidence or by circumstantial evidence. And there are some very unique cases where convictions have been obtained where there was no body. And that is actually one of the cases that I'm going to post on here so you can kind of get a look at it and see how they prosecuted it and how it kind of went, and the issues that some of the attorneys faced and things like that. And I think you'll find it very, very interesting. So I mentioned a minute ago to this word proximate cause. Well, what does it really kind of mean? So the cause of death must be directly, closely, and immediately related to the perpetrator or the suspect's criminal act or omission. So now if there is a intervening cause of death which is not the result of the defendant's act, so that death is not connected in a regular chain of causes and consequences, if you will, the defendant is not responsible. However, if a mortal wound was inflicted by an assailant and a second assailant afflicts another mortal wound, neither assailant is relieved of his or her responsibility for the death of a victim. And then kind of going a little bit further into this, because you've read some of these things on the news, one who commits euthanasia or mercy killings, we've heard about those, bears no ill will towards the victim and may even believe the act is morally justified. Nonetheless, he or she acts with malice if able to comprehend that society prohibits this act regardless of personal beliefs. You can find that in People versus Conley. Also, a crime may be murder, although the person killed is not the one whom the accused intended to kill. So a couple of different variations in there when we talk about this proximate cause. So now let's define murder. So we have the definition of homicide. Let's kind of move on now, and we'll talk about defining murder. What is it, and so forth. So Penal Code 187A, murder is the unlawful killing of a human being or a fetus with malice aforethought. Now, this section shall apply to the death of a fetus under law, and that's Health and Safety Code 25950. And malice is defined for murder purposes under Penal Code 188. And this malice word that we'll define a little bit further in a second here can be found two different ways. It can be express or implied malice. And I'll kind of go through that in a little bit more. So now there's a burden of proof also for murder that I want to hit on before we get into malice a little bit. But in Penal Code 189.5, it talks about the burden of proof for murder. So upon a trial for murder, the commission of the homicide by the defendant being proven, the burden of proving the circumstances of mitigation or that justify or excuse it, okay, basically devolves upon the defendant, unless the proof on the part of the prosecution tends to show that the crime committed only amounts to manslaughter or that the defendant was justifiable or excusable. So the burden of proof here for justification or excuse is going to be on the defendant. And that word malice, give you a little bit more of a definition. Such malice may be express or implied. It is express when there is manifested a deliberate intention unlawfully to take away the life of a fellow creature. Now, it is implied when no considerable provocation appears or when circumstances attending the killing show an abandoned or what they call a malignant heart. Now, you've also probably heard this phrase malice aforethought. Or like, what does that kind of mean? Like, the person killed this person with malice aforethought, and you've heard that premeditation. So let's talk about malice aforethought and kind of get that out of the way. So malice aforethought does not necessarily mean an actual intention to kill the deceased, nor does it necessarily imply deliberation. Rather, it indicates a purpose and design as contrasted with accident or mischance or even misfortune. It is present when there is an intention to cause death or grievous bodily harm, or knowledge that one's acts will probably so result when committed in the commission of a felony or other act which proves inherently dangerous to the others. Malice does not necessarily mean hatred or personal ill will toward the person killed, nor an actual intent, okay, to take the victim's life or anyone's life for that matter. Thus, if the killings was for the purpose of robbery without any hatred or ill will against the person killed, it would be homicide. In this case, the crime would be first-degree murder. So now let's kind of drill down again. And I know that's a little bit repetitive, but I want to make sure you got it. Hit that express and imply just a little bit more, and then we can kind of move on. So as stated in Penal Code 188, malice is express when there is manifested a deliberate intention unlawfully to take away the life of a fellow creature. Express malice must always be present in first-degree murder. It is considered to be present where the evidence shows a deliberate intention unlawfully to take the life of another human being, such as where one kills another with deliberate and formed design. Okay, so an example here, where homicide is committed by means of torture, the means used are conclusive evidence of express malice, and hopefully that example kind of makes sense. Now, on the other hand, implied malice, as stated in Penal Code 188, malice is implied when no considerable provocation appears or when the circumstances attending the killing show an abandoned or malignant heart. Implied malice has been defined as that which arises or may be inferred from the intentional doing of an unlawful or wrongful act with a wrongful purpose. Implied malice exists where the killing was done suddenly, without justification or excuse, and without provocation or without provocation sufficient to reduce the homicide to manslaughter. So malice is an element of murder, or malice as an element of murder is implied where the defendant, with antisocial motives and with utter disregard for human life, engages in conduct involving high probability of resultant death. So does that kind of make sense a little bit? Okay, hopefully it does, and it kind of gets those two things kind of cleared up. Well, here is a little bit more, but a little bit more focused in. So we just went over this: express malice, deliberate intention to take a life of a fellow creature must always be present. First-degree murder. Implied, the killing shows an abandoned and malignant heart. We talked about that. This means a wanton or conscious disregard for human life. Example here: driving recklessly at dangerously high speeds near a school and subsequently killing a child. So that hopefully kind of clears up that thing a little bit. And then we already went over malice aforethought, but it never hurts to review, because sometimes I get a little bit ahead of myself because it is super exciting stuff. This term comes from the old common law It means the requisite mental state for murder encompassing an intent to kill. This intent includes the intent to inflict great bodily injury, reckless indifference to human life, intent to commit a felony. Now, malice aforethought is not limited to a simple intent to kill. It can also mean a purpose or design that leads to the unlawful killing of another. And the example that they have listed here would be the felony murder rule. And we'll talk a little bit about the felony murder rule a little bit later on. So let's move on here. So degrees of murder. So yes, there are degrees of murder, and that's kind of what we're gonna talk about right now. So under Penal Code 189, all murder which is perpetrated by means of destructive device, explosives, a weapon of mass destruction, knowing use of ammunition designed primarily to penetrate metal or armor, poison, lying in wait, torture, or by any other kind of willful, deliberate, and premeditated killing, or which is committed in the perpetration of or attempts to perpetrate arson, rape, robbery, burglary, mayhem, kidnapping, train wrecking, my favorite section, or any act punishable under section 206, 286, 288, 288A, 289 is murder in the first degree, and all other kinds of murder are of the second degree. I know it's a lot. The slide kind of hones it down a little bit and takes the bigger pieces for you, so you can kind of understand a little bit there. So first degree murder, all murder perpetrated by the following, and you can kind of read there. And then again, all of the other ones are second degree. So now we're gonna hit that phrase that we saw a couple slides ago that talks about degrees of murder, and we're going to talk about the felony murder rule. Okay, and this is very interesting kind of piece of law, if you will. And this is where actually kind of reading in your book will also help you define some of these things. Now, if you look on page 172 and 173 in your textbook, before we go any further here, you're gonna see some of those small areas that we skipped over that might be good for you to kind of study. So in the section that I just read before that talked about first degree murder using a destructive device, well, it will define what a destructive device is. It will define poison. It will define torture, lying in wait. Those words deliberate and premeditated, those will be defined. And actually, I may even go over deliberate and premeditated real quick. But I want you to see that the book has these little pieces that you need to read so you can connect all the dots again as we kind of talk about stuff. So real quick, let's hit that deliberation and premeditation definition so we can move on to this part right here and finish up on the degrees of murder. So deliberation and premeditation, the term deliberate means arrived at as the result of some thought and weighing of consideration. And the term premeditate means to think on and resolve in the mind beforehand. Okay, and no set rule can be laid down as to the amount or type of deliberation necessary in every case for first degree murder. The evidence must be sufficient to enable the jury, okay, which will be the trier of fact in these cases, to reasonably conclude that the defendant's action in connection with the homicide was actually premeditated. So hopefully that kind of understands that. So to establish the crime of first degree murder, deliberation and premeditation may be inferred from proof of facts and circumstances and direct evidence of a deliberate and premeditated purpose to kill is not required. So now we're going to swing back over here and finish up degrees of murder and talk about the felony murder rule. So if a death occurs during the perpetration or carrying out or attempt of one of the following serious felonies below on this list that you see, it is first-degree murder. Okay, so and the easy one to think of is, you look at robbery down there. So it's burglary, arson, rape, robbery, mayhem, kidnapping, train wrecking, my fave, certain sex crimes, and drive-by shootings. Well, if somebody goes in, if two robbers go into a liquor store and they're going to rob the clerk, and during the robbery the liquor store clerk is killed, then this felony murder rule will kick in, because it says if a death occurs during the carrying out, perpetration, or attempt of one of the following felonies. Okay, so that should kind of hone that up, and we have a pretty decent understanding about that. Now, there's a lot of terms, again, excuse me, that you're going to hear me talk about, especially in this, in this whole criminal law class, which is really why it's important that you take those little terminology quizzes, because A, they're not graded, and B, when I post the answers, and I know you're going to do them before I post the answers, you can compare and see how you did and have a good understanding, again, of each chapter as we move through. So important terms: premeditation, to think about and resolve in the mind beforehand, conscious consideration; deliberation, deciding after some thought and weighing of options fully considered; lying in wait, waiting and watching for something to occur with the intention of inflicting bodily injury on another, kind of like an ambush. So what are some of the penalties for murder? Well, you'd be surprised what some of those penalties are, and maybe you wouldn't. So the penalty for first-degree murder is either death, life in prison without parole, or state prison time of 25 years to life. Now, the penalty for second-degree murder is state prison time of 15 years to life. Now, first-degree murder with special circumstances, death penalty circumstances may include intentional murder carried out for financial gain using an explosive or destructive device. Victim is a law enforcement officer or fighter. Victim is a witness, prosecutor, judge, public official. Victim is intentionally killed based on race, color, religion. Okay, like as in a hate crime. So those are first-degree murder cases that could be special circumstance cases. Now, if you look at page 173 in your textbook under section 11.4, it will have the penalties for a lot of different things. You don't have to memorize them all, but like for drive-by shootings, for other types of murder, and it's good that you read through those and kind of get an understanding again on how these things go. Now, keep in mind there might be other enhancements using firearms and things like that, or gang enhancements that can make these penalties more severe or longer, but this is just a very good baseline for everyone to start when we're trying to figure out and we're talking about penalties. So here are some of those sections that I was just kind of referring to. First-degree murder you can find in Penal Code 190A, and you can see how they list all these down here, and you can go in or go into your textbook at any time and kind of take a look at those and get a better understanding on some of those. So now let's look at excuse me, proximate cause as it relates to the felony murder rule. Now, the felony murder rule, vicarious liability and proximate cause were talked a little bit back in chapter 3. A little bit of a review would probably be helpful. So as previously indicated, a murder liability is attributable to a suspect under the felony murder rule where he or his or her co-conspirator kills during the commission of a serious felony in furtherance of a criminal conspiracy, if you can remember back when we talked about that. Also, each conspirator is liable for a murder committed by any of them in a case where all had agreed to kill, such as in a drive-by shooting or a murder pact, if you will. And, okay, under the Proximate Cause Provocation Act doctrine, surviving accomplices can be convicted of murder where their conduct was proximate or was the proximate cause of a lethal response by the victim or police, resulting in the death of one or more of those accomplices. Now, a good review for of these three theories attributed to liability can be found in a couple of different cases that I would suggest you take a minute and look at. One would be In Re Aurelio. It's Aurelio, or you could see People versus Concha, which is Concha. If you put those in your web browser and Google them, you should be able to come up with some good information that'll kind of help you more. So now back to this proximate cause felony murder rule thing. So we talked about that. Each conspirator is liable for a murder committed by any of them. And we talked about killing is during the commission of a serious felony, furtherance of criminal conspiracy in a case where all had agreed to kill, and those surviving accomplices as well. So now this is where it's going to get a little bit confusing, but I did put some cool slides in that will help you understand. So we've got murder, but you've heard of these phrases before, okay? Manslaughter. And manslaughter is the unlawful killing of a human being without malice. We know what malice is, right? Okay, the confusing part is there are three kinds of manslaughter. Now, one's going to be easy to figure out, okay? And that would be, well, you tell me. Okay, you've figured it out. Vehicular. It has to involve a vehicle. So let's just kind of go with that. So Penal Code 192 talks about manslaughter and what is it, but there are three different kinds. There's voluntary, there is involuntary, and then there is manslaughter. Well, what's the difference then between like murder and manslaughter? Well, let me go back because I'm like way too fast on the button here. The distinction between murder and manslaughter is that murder requires malice and manslaughter does not. That's a very easy way to kind of figure it out. So now stay with me as we try to discern these different areas of manslaughter, okay? First, we're going to start with voluntary. So we know Penal Code 192 talks about manslaughter. So 192A, voluntary manslaughter. Voluntary manslaughter is committed when a person intentionally and unlawfully kills another person by sudden quarrel or heat of passion. It may also be committed when a person kills unintentionally in a sudden quarrel or heat of passion, where the person acts without conscious disregard for life, or when a person kills another in an unreasonable belief in having to act in self-defense, and they call this imperfect self-defense. Heat of passion means anger, resentment, fear, jealousy, the type of passion that would be aroused in the minds of the ordinary, reasonable person. That kind of makes sense. So hang on to that one for a minute, okay? So we have that. Voluntary, sudden quarrel, heat of passion. Just kind of remember those words and you'll kind of get it. Now, moving on, I mean, kind of staying with the same thing for a second, voluntary manslaughter here. There's a couple of phrases that really kind of are a must for us to know. So adequate provocation must be determined by viewing how the ordinary reasonable person under the same set of circumstances would have viewed it for voluntary manslaughter. And then there's a thing called cooling time. So if a person has had time to basically cool off and then commits the killing, it can be charged as murder. The time to cool off is based on that reasonable man theory again. So let's try to have an example. So a husband comes home and opens the door and finds out that maybe his spouse has been cheating on him, and goes into a fit of rage and jealousy and blah blah blah, and in that heat of passion or whatever, he kind of loses it and he kills his spouse. So think about that in a more global thing, okay? Let's view that under the ordinary reasonable person under the same set of circumstances type thing. Okay, stay with me. Or think of this, okay? Same scenario, husband comes home, finds out his wife's been unfaithful, goes into a fit of rage, blah, 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 cools off, waits 4 or 5 hours, or maybe sleeps it off until the next day, and then kills his wife. Difference, right? So you can see that cooling off period thing. So it'd be the same with maybe two guys fighting in a fist fight over whatever it is, and during the fight, someone maybe is killed or something, versus the fight's over or the fight stops, one guy goes home, gets a gun, and comes back. Cooling off time. Okay, so I'm not trying to confuse you. I just want you to know that these are very important pieces to that. So that's voluntary. Sudden quarrel, heat of passion. Now let's move to involuntary. 192B, involuntary manslaughter is the unlawful killing of a human being without malice under the following conditions: in the commission of an unlawful act, not a felony; in the commission of a lawful act which may produce death in an unlawful manner if done without due caution and circumspection. So involuntary manslaughter, again, in the commission of an unlawful act not amounting to a felony, or in the commission of a lawful act which might produce death in an unlawful manner or without due caution and circumspection. Okay, are we kind of okay? Now, if not, I'm going to go into these just a little bit more after the last one, okay? So we're going to hit vehicular manslaughter, and then I'm going to wrap back around, and I'm going to talk about these three kind of one more time, and then we're going to move on. All right? So, because I want to make sure that we can get through the whole chapter. Vehicular manslaughter, 192C1, you can see it has C2, C3, C4. Vehicular manslaughter is defined as driving a vehicle during an unlawful act, not a felony, with gross negligence, or commission of a lawful act which might produce death, done in an unlawful manner with gross negligence. Now, I know this is confusing, but just kind of hang with me. Or driving a vehicle during an unlawful act, not a felony, without gross negligence, or commission of a lawful act which might produce death, done in an unlawful manner without gross negligence, or driving in violation of California Vehicle Code 23140, 23152, and 153, DUI, under the influence with or without injury, in commission of an unlawful act, not a felony, and with gross negligence, or done in commission of a lawful act which might produce death, done in an unlawful manner without gross negligence. Yes, I know I'm talking fast. And C4, driving and causing an accident for the purpose of insurance fraud. So these are the three types that we kind of talked about. Now, negligence, when you talk about that, because these words kind of come up, that word negligent or negligently basically import a want of such attention to the nature or probable consequences of the act or omission as a prudent man ordinarily bestows in acting in his own concerns. And we'll get through some of this kind of rhetoric here in a minute. So a little bit more on vehicular manslaughter. The punishment, both voluntary and involuntary manslaughter are felonies punishable by imprisonment in the state prison. Voluntary manslaughter is punishable by imprisonment in the state prison for 3, 6, or 11 years. Involuntary manslaughter punishable by imprisonment in the state prison for 2, 3, or 4 years. Vehicular manslaughter punishable either by imprisonment in the county jail for not more than 1 year or by imprisonment in the state prison for 2, 4, 6, or 10 years. So now let me back up real quick. And again, we don't want to spend too much time, but I want to cover this. Let's go back for a second and just a little bit more on voluntary and a little bit more on involuntary so we have a good idea. So voluntary manslaughter is committed when a person intentionally but unlawfully kills in a sudden quarrel or heat of passion. Okay, we got that. It may also be committed when a person kills unintentionally in a sudden quarrel or heat of passion where the killer acts with what they call a conscious disregard for life, knowing that the conduct endangers the life of another. Okay, in either kind of case, the crime is less than murder because of the absence of the element of malice. A person who is acting under provocation of sudden emotion is not deemed culpable as a person acting from a malicious motivation to kill. Okay, voluntary manslaughter may also be committed where a person kills another intentionally in a unreasonable but good faith belief in having to act in self-defense. Okay, so we kind of talked about that. And so moving on now to involuntary manslaughter, every killing of a human being is involuntary manslaughter if it isn't murder. Okay, voluntary manslaughter or excusable homicide under Penal Code 195 or justifiable homicide under Penal Code 196 or 197. So involuntary manslaughter is the unlawful killing of a human being without malice. Okay, and the crime exists in two situations that we talked about before. In the commission of an unlawful act not amounting to a felony, or in the commission of a lawful act which might produce death in an unlawful manner if done without due caution and or circumspection. And I know it's confusing, but that's okay. And vehicular manslaughter, let me give you some examples and then we're going to move on. So driving at an excessive speed, hitting a person standing by the roadway near a parked car is manslaughter in the driving of a motor vehicle with gross negligence if death occurs. Failure to stop at a traffic signal, all conditions being normal, which results in the death to another driver was sufficient to sustain a conviction for manslaughter for grossly negligent operation of a motor vehicle. Last one, death which results in a driver being blinded by approaching lights of another vehicle and where the driver, as a result of his visibility being impaired, strikes and kills a pedestrian in a crosswalk, is manslaughter in the driving of a vehicle without gross negligence. And there you have it. So hopefully that kind of didn't confuse you too much. So we kind of went over this, but I hope those examples helped. To be deemed vehicular manslaughter, the homicide must be the proximate result of the unlawful act or the lawful act which might produce death committed in an unlawful manner. It is ultimately up to the trier of fact, the judge in a bench trial and the jury in a jury trial, to determine if an act was done with or without gross negligence. So moving on now. So we've talked about a couple of different things. Now let's move on to the last little pieces. Excusable homicide. Well, when can we excuse homicide? I mean, well, let's kind of take a look now. Homicide is excusable in the following cases: when committed by accident or misfortune, or in doing any other lawful act by lawful means with usual and ordinary caution and without any unlawful intent. When committed by accident and misfortune in the heat of passion, upon any sudden and sufficient provocation, or upon a sudden combat, when no undue advantage is taken nor any dangerous weapon is used, and when the killing is not done in a cruel and unusual manner. So hopefully that kind of sort of sheds a little bit of light on that. Now, to excuse homicide on the grounds of accident and misfortune, the accused must have been engaged in a lawful act, and he must have been performing it with due care. If he was engaged in a lawful act, or if the accident was a result of culpable or at-fault negligence, he is criminally liable for the consequence of this act. So hopefully that kind of clears that little part up there. And then finally, as we're starting to get towards the end here, we'll talk about justifiable homicide by public officers. Homicide is justifiable when committed by public officers and those acting in their command and their aid and assistance, either in obedience to any judgment of a competent court, or when necessarily committed in overcoming actual resistance to the execution of some legal process, or in the discharge of any other legal duty, or when necessarily committed in retaking felons who have been rescued or have escaped, or when necessarily committed in arresting persons charged with a felony and who are fleeing from justice or resisting such arrest. You can find this in Penal Code 196. Now, the characteristic of a justifiable homicide is that while the officer may have the intent to kill and the action he or she takes is likely to result in death, the occasion, okay, is such that the law justifies the killing as a means of protecting and enforcing the rights of an individual, the community, the officer, or the state. And to be considered as justifiable homicide, the killing in the overcoming of resistance to a legal process or the discharge of any other legal duty, in fact, been necessary or have reasonably appeared to be necessary. Okay, if the duty could not have been reasonably performed without killing, it would not be a justifiable homicide. So there you have it, Penal Code 196. Now, there are other sections in here that have that talk about justifiable homicide by other individuals, so by private persons, protecting their home. 198.5. That's actually kind of an interesting one to read. Self-defense, and then justifiable, excusable homicide found under Section 199. So I would suggest that you take the time to kind of look at those and understand. Now, look at we talked about this a couple of chapters back. I would also take a look at Penal Code 198 that talks about this thing called bare fear, meaning that that just simply fear will not justify a killing in defense of your home. Okay, circumstances must be sufficient to excite the fears of a reasonable person, and the person using lethal force must have acted under the influence of such fears alone, okay, in order to make it killing. And self-defense, and applying the law of self-defense, a person must act in a reasonable and prudent, as a reasonable and prudent individual would act under certain similar circumstances. Okay, the degree of force used to defend oneself must be proportionate to the injury threatened. One cannot kill a person, for example, who threatens to commit simple assault or battery. All right, the necessity for committing homicide must be founded upon a grave apprehension, if you will, of receiving great bodily harm. Does that make sense? Okay, cool. So capital crimes, we're not going to spend a lot of time on that, but here are a list of those where a defendant could be sentenced to death if 18 or older, if first-degree murder is committed under any of these following sections right here. And then finally, well, maybe not finally, here's some more. Here it is. Okay, so what I did is to try to help you understand these chapters, all of these things, these justifiable homicide and murder and excusable and manslaughter, voluntarily, involuntarily, vehicular. I put together a chart for you. And this chart will help you, because if you look on the left side, it talks about murder, unlawful, and felony. It says first degree, second degree, and then you look on the right side, it's got the first degree and second degree. So we know that those, remember the list of those crimes that make it first degree? Well, that's there. Okay, and then even all the way on the left, it talks about first degree, remember express malice, second degree implied, and it gives you the definition of malice down here at the bottom. Okay, and the difference between first and second degree as well. Now you look in the middle here, and it talks about lawful, okay, homicide, if you will, or death. Justifiable gives you the definition, excusable. And then you go to the right, and it talks about the manslaughter sections, the voluntary, the involuntary, and also vehicular. So it kind of breaks those down for you, which makes it cool. And then here's just smaller little cheat sheets, if you will, that you can kind of look at if you don't want it all on like one page. So hopefully that kind of helps you get through the fear of all of those terms. So that's going to be it for Chapter 11 homicide. I'm going to post a couple of videos. One might be a death penalty video that I think is really interesting for you to watch, or the other one might be a homicide case where they actually could not find a body, and that's a very, very interesting one as well. So you'll get to view one or both of those, and I would highly suggest that, again, you do your terminology quiz. So we're going to be done with Chapter 11, and that's it. If you have any questions, put them up on the discussion board, and until next time.